There are so many breaking and fast-moving stories in Donald Trump's legal world today. You gotta be on MeidasTouch Network and on Legal AF just to keep up. We got a new order on an emergency application that Donald Trump and his lawyers just filed this morning at the Appellate Division First Department, which is the Manhattan Appellate Court, if you will, for all things in his criminal life, in which they tried to convince a justice of the Appellate Court, Justice Ellen Gessmer, to grant an emergency ruling, an emergency order to block Friday's sentencing of Donald Trump for his 34-count criminal conviction. And we've got the ruling by Judge Gessmer already. I'm Michael Popok. You're on the MeidasTouch Network and on Legal AF. And let me not bury the lead. Justice Gessmer has denied the emergency request. She is not going to, on an emergency basis, block the sentencing of Donald Trump scheduled before Judge Merchan on Friday, something that he can attend virtually. There was a debate, broke out, an oral argument in the courtroom in the First Department in Manhattan on Madison Avenue. You had Todd Blanche, soon to be in the Department of Justice, but currently Donald Trump's lead criminal defense lawyer on one side. You had Stephen Wu for the Manhattan DA's office on the other. It all came down to immunity arguments. The Manhattan DA's position, of course, is there is no presidential-elect immunity, that everything related to this case happened before Donald Trump was ever president. The criminal conduct was before he was president, the indictment before he was president, the trial before he was president, the conviction before he was president, and the Friday sentencing before he's president. So what's the immunity hubbub all about? That's basically the argument for the Manhattan DA. On the other side, of course, you know what Donald Trump's arguments were in his filing papers and in his oral argument directed to Justice Gessmer, and it's immunity, immunity, immunity. He's the president-elect. He's got president-elect duties. They'll be interfered with if he's got to be sentenced. Look, Donald Trump does not want to go before Judge Merchan, even though he already knows that Judge Merchan is not going to sentence him to jail because Judge Merchan has already said he's not going to. He's going to do an unconditional disposition or discharge, meaning the felonies stay on Donald Trump's record, all 34 of them. But he's not going to serve any time. He's not going to pick up trash on the side of the road. He's not going to do any of that. Donald Trump's not satisfied with that. Why? Because in a full-blown sentencing hearing, the judge, in writing and orally, is going to chastise Donald Trump. He's going to recite all the bad conduct that the jury found against him. He's going to recite all the bad conduct the judge found against him in contempt 8 or 9 times. All the acting out and lashing out and vitriol and crossing the line and attacking the judge for being a criminal, attacking the Manhattan DA for being a criminal, claiming that there was a coordination with the Biden Justice Department or Biden himself. All those lies are going to come home to roost during a sentencing hearing. That's what judges do. He's going to talk about the failure to accept responsibility, the failure to show remorse. And Donald Trump doesn't want to sit for any of that. He wants to have a victory lap before his inauguration. I've said it before. There's a cold, hard rain falling right now on Donald Trump. Last week, he loses the E. Jean Carroll appeal on his way to paying her $100 million for sexually assaulting, defaming her, and being hit with punitive damages. Now, he's not going to be able. He's already lost 2 different motions by Judge Merchan in the last week to try to throw away the convictions by a 12-0 jury. And now he's trying to convince Ellen Gessmer. Now, let me explain it to you from a New York practitioner standpoint, because I practice in this court. I practice in the First Department. I've argued there. I'm actually admitted there. I was sworn in there as a young lawyer in 1992. Can't believe it. Justice Gessmer is effectively the duty judge. She was on duty today when the papers came in. There's one justice that's responsible for emergency applications. 5 justices generally sit, sometimes 6, to listen to oral argument and make ultimate decisions on the merits of a case. But if you want an emergency application, you got to go fishing and see who's there. And whoever's there, depending upon who's there, you might get your emergency motion granted. They wanted to stop Friday to allow for the full appeal on the immunity issues. The Manhattan DA's argument was they're going to lose on the immunity issues and let the matter finally conclude before he's in office, before he's inaugurated on the 10th, and then he can appeal the entire kit and caboodle up to the appellate courts. But right now, the record is still incomplete, and justice demands that we finish and sentence Donald Trump. That's the argument. This particular judge on duty, Ellen Gessmer, ruled against Donald Trump. Now, in the past, Donald Trump has been successful. There's one justice in particular that he's randomly drawn a couple of times that had issued temporary injunctions, temporary stays, pending the full panel making their ruling, but not Judge Gessmer. She's not going there. Now, it doesn't mean that she's going to be on the panel for the full-blown appeal. She may or may not be. It depends upon how that lottery wheel spins, that random selection wheel. But she has set a briefing schedule, which she's allowed to do in her capacity as an emergency duty judge. She says the motion is going to be heard or returned before the entirety of the panel, the 5-justice panel, on the 21st of January. That's interesting. A day after the inauguration. So a day after the inauguration, Donald Trump is going to be filing papers before this Appellate Division First Department on his full-blown brief and emergency application. She wants the opposition papers from the Manhattan DA by the 14th. She wants a brief reply in the morning of the 21st, and then they're going to have oral argument at some point thereafter. So obviously, she knows how a calendar works and where the inauguration falls and picked a date after the inauguration. But as of right now, what does it mean? It means as of right at this minute, at 2 o'clock Eastern time, because this is how fast this story is moving, Donald Trump has failed in his first attempt to get the Friday sentencing postponed by an appellate court. He can try a couple of other things. He can try another emergency application, a slightly different way to the same court. I think that fails. He can try to skip the Appellate Division First Department and go directly to the highest court in New York State appellate world, which is the Court of Appeals, and try there. That's a harder and even narrower path because of the grounds that you have to allege up there. It's even more difficult to thread that needle. So that's going to be hard. And he could just say, all right, I've got big problems, try to take the case to federal court, which he's tried to, and it's been rejected before, try to lob an emergency application for an emergency stay or writ into the United States Supreme Court on the federal side. But I think the first stop on that train has to be Sonia Sotomayor, because she's responsible for all things New York. She's not going to grant that. Maybe she'll think because of the immunity issue being raised, they need to bring it to the full 9-justice Supreme Court. I think it's slim to none chance that the Supreme Court is going to interfere in this area. They're going to argue on the Donald Trump side that this goes right to the heart of their immunity decision and the fact that they didn't want to have presidents being prosecuted for crimes committed, and he's the president. There's presidential absolute immunity, but that's not how that immunity decision works. We've analyzed it extensively in Legal AF. It's about when somebody who was president is being prosecuted for crimes while he was president. And you have to determine whether the crimes that he's being prosecuted for are based on conduct that are absolutely immune because it arises under his Article 2 power under the United States Constitution, and it's listed in the Constitution, or it's a part of his official conduct stretched to its outer boundaries. That is all going to have some level of immunity. But if it's private conduct, then it's not. And that was only about whether he could be prosecuted and participate willingly or unwillingly in a criminal justice system. We're beyond that. This is about conduct before he was president. The trial happened already. The conviction happened already. He's been convicted before he was elected president again. And he's not even president today, as Stephen Wu reminded Judge Gessmer. We have one president at a time, and his name right now is President Joe Biden, until it's not, until 12:01 on the 20th of January. I mean, let's just think of it that way. While Joe Biden is sitting in the audience, and he is going to go to the inauguration because he's a decent guy, while he's in the audience, until the oath of office is given by the Chief Justice to Donald Trump swearing him in on that strike of noon, he's President Joe Biden. When he walks into that crowd, Hail to the Chief should be played, and it's for Joe Biden, not for Donald Trump. You only play Hail to the Chief for one guy at a time. And that was Stephen Wu's argument today for the Manhattan DA. So is there a path in the state appellate court system for another attempt at a stay now that Donald Trump has failed to get the trial judge to do it, the first level appellate court to do it? Yeah, there's probably one more Hail Mary at the Court of Appeals level. We may see that application today, and I'll be right back here or on Popak Live tonight at 8 p.m. Eastern Time on YouTube for MeidasTouch, catching you up on all this. Then there may be an attempt at a federal intervention, trying to not take the case to federal court, because he tried that and lost, but to try to lob in an emergency application for stay at the U.S. Supreme Court level, but I don't think he gets past Sotomayor. But if he does, or he tries, come right back here to Legal AF and the MeidasTouch Network, and we'll catch you up on it. So until my next reporting, Legal AF here or Legal AF, the YouTube channel, in collaboration with MeidasTouch. I am Michael Popak, and I'm reporting. In collaboration with the MeidasTouch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.